Well, good morning, everyone, and welcome back to AJ111 Criminal Procedure. My name is Tony Farrar, and of course, I am your instructor for this semester. This morning's lecture is going to cover Chapter 10, which is going to include the exclusionary rule. That's funny. Get it? Include and then exclude. Okay, anyway. And entrapment. And as kind of a precursor, I wanted to play this very quick video for you. And you may have watched it in the introduction portion of this chapter, but if you didn't, let's just take a look at it.
Can I ask you one question?
Anything.
Since you've been so helpful walking me through what evidence the FBI has, I was hoping you might confirm for me something I've suspected for a long time but could never get a straight answer to. But it seems to me that there is no forensic evidence whatsoever tying me to these heinous crimes besides what you found in my cabin.
Yeah, but there's so much evidence of every type.
Imagine if you could throw out all that evidence. There'd be nothing left, right? Because it's all here on the table. You just laid it all out in front of me.
Yeah.
James, do you really not have any idea why I brought you here? Huh. This is your search warrant. It's based on your linguistic analysis. This is what got you into my cabin, and the prosecution's entire case rests on this one document, your document.
No, what's he doing?
So I thought we could discuss something I learned about only recently called fruit of the poisonous tree. That's the option that you're neglecting to mention, the option where I get all this evidence thrown out and I walk away a free man. The only evidence connecting me to the Unabomber attacks was found inside my cabin. The only reason the FBI was legally allowed to search my cabin was because of your search warrant. But if that search warrant was issued on false pretenses or based on arguments that fail to meet the burden of proof, well, then all the evidence found at that location is deemed fruit of the poisonous tree. It's tainted. It's inadmissible. It's got to be thrown out. So if the search warrant goes, then all their mountains of evidence simply disappear.
Okay, so welcome back after the video. So who was Ted Kaczynski? Well, he was also known as the Unabomber. He was a mathematics prodigy, if you will, and he actually taught at the University of California, Berkeley, before retreating to a survivalist lifestyle in the Montana woods. Now, between about 1978 and 1995, Kaczynski mailed bombs to different universities and airlines. He ended up killing 3 people and injuring 23 more. And FBI agents, after many, many years, finally were able to track him down and arrest him in 1996. And then subsequently, 2 years later, he was sentenced to life in prison. Now, the reason I bring that up is because the video actually portrayed a simple truth, and we're going to learn more about that phrase, fruits of the poisonous tree, but it's all part of the exclusionary rule. So I hope that, and think about that video as we start to kind of go through the lecture, and we'll talk a little bit more about it. But let's start off just quickly with the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and then think about this relating to the video, no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, you saw all of the tables full and boxes full of evidence. and the many years that it took to gather all of that evidence, against Kaczynski, and then finally, arrest him and bring him to trial. But what if something as minute as an issue related to the search warrant actually could cause the warrant to be invalid? And therefore, if the warrant would be invalid, then so would all of the information as a result of that. And that's part of what we're going to talk about here. So the Fourth Amendment, just a little bit more. Remember kind of the summary. It forbids unreasonable search and seizure. And part of that encompasses the unreasonable portion is the exclusionary rule, which we can find in a couple of different cases, two important cases. The first case would be Weeks versus United States, and the second case would be Mapp versus Ohio. Because at the end of the day, whether you're going to make a warrantless arrest or if you're going to apply for a search warrant, both of those instances are going to require probable cause. So the text of the Fourth Amendment is pretty silent. It actually is silent on the consequences of an unreasonable search and seizure, meaning like, well, what happens if somebody violates that? So should all the evidence be excluded at trial? Or what type of penalties should law enforcement face if they violate that? The Fourth Amendment. Or what type of compensation, if any, should the subject of the unlawful search receive? So these are all questions, and the Supreme Court has dealt with a lot of these questions. Now, historically, federal agents and state police who carried out unconstitutional searches and seizures were subject to civil suits for the return of property or for damages. They were criminally prosecuted or even subject to internal discipline. However, even in light of those things, the evidence was still allowed in. So there were some penalties, but the evidence was basically allowed in. So critics, and I can see what the complaint would be, would argue that these penalties were somewhat ineffective because at the end of the day, the evidence was still allowed in. Does that make sense? So it seemed to be a little bit ineffective. So as we discuss this topic a little bit further, I would like you to just kind of keep in mind that we're going to be looking at the Fourth, the Fifth, and the Sixth Amendment as it relates to the exclusionary rule, and then towards the end of the chapter as we talk a little bit about this thing called entrapment. So the Weeks versus United States case, it's an old case. It's back in 1914, and I have a link to not only the case but also to a video. But in 1914, in Weeks versus United States, the U.S. Supreme Court ruled that the Fourth Amendment required that evidence seized in an unlawful search was to be excluded from use as evidence in federal court. So, okay, that's a great rule, and, it kind of helped, but the rule did not apply to the state courts. It was simply just the federal court. So again, in this Weeks case, the Supreme Court did rule that the Fourth Amendment required that evidence seized in an unlawful search was to be excluded in federal court, but it was not applicable to state courts. Now, a little bit later, in the case of Wolf versus Colorado in 1949, the requirements of the Fourth Amendment were incorporated into the 14th Amendment and were applicable to all the other states. The Supreme Court, however, also ruled that states were not required to exclude from trial evidence obtained in violation of the Fourth Amendment. And I have a link to that case too, if you would like to take a look at it. So we have some, kind of a new case here that really did incorporate the requirements of the Fourth Amendment into the 14th Amendment, but the Supreme Court still kind of held fast and ruled that states were not required to exclude evidence from trial that was obtained in violation of the Fourth Amendment. Well, then along came the MAP case. And I have a link to a couple of different videos and the case for MAP versus Ohio 1961. And this is a really important case. So in 1961, in MAP versus Ohio, the U.S. Supreme Court basically sent shockwaves through the criminal justice system by extending that federal exclusionary rule to criminal trials in both state and local courts. So now you can see a little bit of a shift, right? And it was kind of interesting. The court explained that the exclusionary rule was basically required to deter the police from disregarding constitutional standards and also to maintain the integrity of the judiciary by excluding unlawfully seized evidence from trial. So the Supreme Court shortly thereafter held that the exclusionary rule was in fact, a judge-made remedy rather than a remedy that was guaranteed by the Fourth Amendment to the U.S. Constitution. So the sole purpose, really, of this judge-made exclusionary rule was to deter unreasonable search and seizure. So does that kind of make sense? So remember, if we kind of back up, at first, we have the exclusionary rule that is only applicable to federal courts and federal trials, and that's under the Weeks case. And then when the MAP case comes along, the Supreme Court basically says, well, this needs to extend all the way through to state and local courts. And just to point out again one last time, this was a judge-made remedy for unlawful searches and seizures. So it wasn't something that was built into the Fourth Amendment. And so just to kind of ask the question, I think I already said it, but the sole purpose of this judge-made exclusionary rule was to do what? And the answer would be to help deter unreasonable search and seizure. Because now, while there still could be some penalties, you're going to lose your evidence. And it doesn't matter what the evidence is. It could be the smoking gun for a triple homicide, and it won't make a difference. So hopefully that kind of clears up the issue there. And a little bit more, the exclusionary rule really has been a primary flashpoint in the debate over whether the American criminal justice system has maybe gone a little bit too far in protecting criminal suspects while disregarding the interests of victims in society. So, are we kind of pushing the envelope and going too far to exclude some really piece of evidence that needs to get into trial? But again, the court held pretty well, stand fast on that. And critics will also ask whether it makes sense to exclude this reliable evidence from trial and thereby permit criminal defendants to go free without having to confront all of the evidence against them. So, back like in the Unabomber case, let's just say that was in fact a violation of the Fourth Amendment, and all of the evidence against him was thrown out that was obtained through the warrant. But you had all that evidence. So where do we kind of draw the line in this entire thing? So in the first part of our discussion, we're going to look at the evolution of the exclusionary rule. And I'd like you to pay particular attention to the development, if you will, of the exclusionary rule following Mapp versus Ohio. And ask yourself whether the Supreme Court has unduly limited the exclusionary rule or has struck the proper balance. Do you kind of agree or disagree? And keep in mind that the exclusionary rule applies to searches and seizures under the Fourth Amendment. And as you may recall, evidence also may be excluded from trial based on the violation of other constitutional amendments, right? And a couple of examples could be suppression of confessions, as we talked about in a previous chapter, or maybe even the suppression of, let's say, an in-court identification. So all of these, we need to kind of, we have to have a better understanding about it, especially as it relates to criminal procedure. Okay, so again, the exclusionary rule provides that evidence that is obtained as a result of a violation of the Fourth Amendment prohibition on unreasonable search and seizure is inadmissible in a criminal prosecution to establish a defendant's guilt. And as we've kind of talked about, the Supreme Court extended that Fourth Amendment exclusionary rule to prosecutions in both state and federal court. So we've kind of, so we know the importance of this, or we really should. So with that being said, derivative evidence. So I'm going to kind of break it down a little bit more. So to kind of give you definition-wise, the exclusionary rule, remember, provides that evidence that is obtained as a result of a violation of the Fourth Amendment prohibition on unreasonable search and seizure is inadmissible in a criminal prosecution to establish a defendant's guilt. Now, the term derivative evidence, or evidence that is discovered as a result of the unlawfully seized items, that is also excluded as evidence. And that is termed fruit of the poisonous tree. So, for example, records of illegal drug transactions, let's say, that are seized in the course of an unlawful search are excluded from evidence because the records are the direct result of an illegal search. Does that make sense? The confessions resulting from the interrogation of an individual whose names are listed as part of the drug transaction will be excluded from the evidence as fruit of the poisonous tree. So, kind of in summary, direct evidence or this derivative evidence is evidence that is directly derived from the unreasonable search. And then fruit of the poisonous tree, this is evidence that is derived from the evidence that is directly seized. And the exclusionary rule remains, nevertheless, again, very controversial. And, sometimes they ask the questions, well, why the reluctance, if you will, on, let's say, excluding items that were unreasonably seized as evidence? And kind of think about that as we talk a little bit more. And we kind of talked about the Unabomber case. And I also threw in a little chart that you can look at that talks about, this is sort of an admissible evidence chart on when things would be admissible or inadmissible. So, just to kind of summarize again, the exclusionary rule excludes the following from trial. We talked about direct evidence. This is evidence that's directly derived, directly obtained from the illegal search or the unreasonable search. And then that fruit of the poisonous tree part, that's evidence that's derived from the evidence. that is directly seized. So hopefully that kind of makes sense. So just a couple of other things just really quick. And I asked the question, why the reluctance to exclude items that were unreasonably seized from evidence. And the primary reason is that this might result in a guilty defendant being set free to, rape, rob, and steal once again. What of the interests of the victims and of society in the conviction of criminals? So we're going to look at a couple of different things. I'm going to kind of talk real quick about the Wolf case again, and then we're going to jump into an extremely interesting case that you'll find in your textbook as well. And I'm not sure if that page number is correct, but so in 1949, in the Wolf versus Colorado case, the U.S. Supreme Court, remember, held that the requirements of the Fourth Amendment were to be incorporated into the 14th Amendment and were applicable to the states. And Justice Felix Frankfurter, at that time, he wrote, security of one's privacy against arbitrary intrusion by the police, which is the core of the Fourth Amendment, is basic to a free society and is therefore implicit in the concept of ordered liberty. So as we talk a little bit more, I wanted to kind of talk about the Rochin versus California case. So this is a really interesting case, and has a lot to do with, well, I'll let you decide whether it was unreasonable. So in this particular case, Rochin, the police suspected that Rochin had swallowed capsules containing illegal narcotics. And as part of their investigation, they ended up directing a doctor to force a vomiting-inducing solution into Rochin's stomach. And the police subsequently discovered 2 morphine tablets. Now, when this case ended up in the Supreme Court ruled that the police conduct basically shocked the conscience of the court and violated the due process clause of the 14th Amendment, and that the morphine tablets should have been excluded from evidence. And a little bit further, the court went on to say in this case, and I have a link to the case and you can look at it if you want, that breaking or illegally breaking into the privacy of the petitioner, the struggle to open his mouth and remove what was there, the forcible extraction of his stomach contents are methods too close to the rack and the screw, meaning a form of torture, if you will, to get people to admit things, to permit constitutional differentiation, meaning like they shocked the conscience of the court. So, this case is used quite often when we talk about maybe forcibly somebody ingests some type of narcotics and the officers are trying to forcibly make the person, let's say, not swallow them or to retrieve the items. But it's a super interesting case. And kind of all in all, a great deal of thought and effort and ink, meaning like paperwork, has been spilled by authors debating the merits of the exclusionary rule, meaning like, why should we keep it, or why should we get rid of it, or is it too far this way or too far that way? So let's take a look at some of the arguments for the exclusionary rule. So the first one would be constitutional rights, because the Fourth Amendment protects individuals against unreasonable search and seizure, and this safeguard would be weakened if evidence seized in an unreasonable search is used at trial. And this is the kind of the essential ingredient, if you will, in the Mapp versus Ohio case. So the next one would be deterrence. The exclusionary rule deters the police from disregarding constitutional procedure in future investigations. And the Supreme Court went on to note in a case called Elkins versus United States that the purpose of the exclusionary rule is to deter the police and to basically compel respect for the constitutional guarantee in the only effectively available way, by removing the incentive to disregard it. And the court also noted that the exclusionary rule is basically calculated to prevent future violations, not repair the past. And hopefully that makes sense. So, it's kind of any future things. It doesn't go back and really take care of the past, but it will certainly deter unlawful search and seizure in the future. And so another justification would be judicial integrity. And in this instance, judges are charged with interpreting and protecting the Constitution, and confidence in the rule of law is promoted by fair and equal enforcement of the law. And for this reason, the court should not turn a blind eye to law breaking by government officials. And that's true. So it is really the integrity. The judges are charged with protecting the Constitution. And there's a case there. I'll give you like a little reading from it. In the case of Olmsted versus United States, it goes on to say the future of the government will be imperiled if it fails to observe the law scrupulously. Our government is basically the omnipresent teacher. For good or for ill, it teaches the whole people by its example. And that crime is contagious, and if the government becomes the lawbreaker, it breeds contempt for the law. It invites every man to become a law unto themselves. It invites anarchy. So again, this came from the Olmsted versus United States case. And then one other argument, the final argument 4, would be the social cost. The social cost of excluding evidence has led police departments to stress the importance of police professionalism and to introduce training programs to ensure that law enforcement personnel follow Fourth Amendment procedures. And by contrast, just to kind of throw this out, a relatively very small portion of cases end up leading to the acquittal of defendants based on the exclusion of evidence. But there still needs to be that strong rule of law that continues to basically not just compel, but make sure that law enforcement officers are complying with all of the elements of the Fourth Amendment, if you will. So with that said, there are also some very equally strong arguments against the exclusionary rule. And we looked at some arguments for, but let's take a look at some arguments against. So again, there are some criticisms. One is basically to include the high cost of the loss of evidence at criminal trials. So just that loss of evidence at trials and basically reduces rather than enhances the respect for the criminal justice system. And again, you don't have to agree with these. These are just arguments against. So let's look at some of the main arguments. The first would be the Constitution. And one of the arguments is that the exclusionary rule is a judicially created remedy, basically. And judges are free to limit or actually even abolish the exclusionary rule. Remember, the Supreme Court has held that the exclusionary rule is a judge-created remedy. And that remedy, again, is intended to deter the police from engaging in unreasonable search and seizure. And if that's the case, that it's judge-made, could it be judge-changed? So that's one of the arguments. Next would be deterrence. Now, former Chief Justice Warren Burger dismissed the notion that the exclusionary rule deters the police from violating Fourth Amendment rights, as he kind of quoted by saying it was a wistful dream. The police are concerned with gathering evidence and with making arrests, and really do not stop to analyze whether a search satisfies the ever-changing and complicated standards for searches and seizures established by the Supreme Court. But on the other hand, the immediate impact of an unreasonable search or seizure is felt by the prosecutor, who loses the evidence, not the officer. Does that make sense? So it's the prosecutor, because the officer has made the arrest, submitted all of the evidence, etc., and then the prosecutor takes over. So one argument against is that the prosecutor is the one who loses, not the officer. And it may take several years and, several appeals for the legality of a search to be decided, because remember, cases can go all the way up to the United States Supreme Court, and we know that that could take a long time. Another argument would be judicial integrity. So the exclusionary rule decreases respect for the courts, the judiciary, if you will, by requiring courts to take the side of defendants rather than the side of the victim. So that, again, that's just an argument. Truth-seeking. The exclusionary rule undermines the purpose of a criminal trial, which is the determination of a person's guilt or innocence based on available and reliable evidence. So again, another argument. Let's look at a couple more. Lack of flexibility. The exclusionary rule, as we talk about it, evidence is suppressed regardless of whether the police committed a technical violation of the law or engaged in what we would call a blatant violation. In both cases, the identical remedy is imposed, and that is the exclusion of evidence. And as Chief Justice Burger observed, this equates the freeing of a tiger and a mouse in the schoolroom as equally serious offenses. So again, I mean, and that's kind of the legalese that was quoted in one of the court cases. Actually, it was quoted in the Bivens case, but you don't need to know the case. You just need to know that sometimes they believe it's a lack of flexibility. Another one would be limited application, meaning that it has no impact on the police in those instances in which the police seize a gun or drugs in order to just get the contraband off the streets. And they really don't care or have any intent on pursuing criminal prosecution. They just want to get everything off of the streets. Does that kind of make sense? So in this instance, there is no evidence to exclude and no penalty paid by law enforcement. The reasonableness of the search and seizure often does not come to the attention of the courts when a defendant does a plea bargain or enters a guilty plea in exchange for a lesser sentence or other consideration. So again, some limited application. Kind of an interesting one, right? There's another one also, and I didn't include it, but there's one more, and that would be penalizing victims. So the protection of criminal defendants undermines rather than promotes respect for the criminal justice system. And this was articulated basically by the U.S. Supreme Court in a case called Irvine versus California. And in this case, the court noted that the rejection of the evidence does nothing to punish the wrongdoing official, while it may and likely will release the wrongdoing defendant. Does that kind of make sense? So what about the victims? They're going to lose their case, and somebody who victimized them might be let free because of an unreasonable search and seizure. So again, it's been a debate for a long time, and we've looked at some of the justifications for the exclusionary rule, and we've looked at some arguments against the exclusionary rule. Now, what would be some alternatives then? So critics of the exclusionary rule argue that deterrence may be more effectively achieved through some alternative procedures that do not require the exclusion of the evidence from trial. So that's kind of interesting. Do you think that, or do you believe that any or all of the procedural mechanisms that we have in place, and we'll talk about a few more and think about it while I'm talking, would be more effective than the exclusionary rule in deterring violations of the Fourth Amendment? So let's look at a few and let's apply that statement. So the first one would be civil tort suits. So civil suits for damages against police officers who have engaged in unreasonable search and seizures and the government. Do you think that would be, does it sound rational? Is it too much? Do you think it would deter law enforcement? It is interesting. There also must be, adequate monetary compensation to provide successful litigants to serve as an incentive for individuals to take, time to engage in a suit. But what about a monetary fine? The next one, criminal prosecution of law enforcement for violation of civil liberties. And prosecutors may be therefore reluctant to bring charges against police officers, particularly for relatively minor violations of law. So maybe it was something that was just a very minor technical issue, but it still qualified for an unreasonable search and seizure. Is that a little much to have criminal prosecution for some kind of a mistake? The next one would be police administrative procedures. Maybe subjecting officers to penalties that include things like demotions or fines or suspensions or termination of employment. Maybe a civilian review board that examines cases of suspected abuse. Or finally, maybe a judicial hearing conducted prior to the prosecution of the criminal charge, where the judge would be authorized to impose an appropriate penalty ranging from fine or suspension, etc. So these are just all alternatives. And, in my own opinion, I think that they're rather harsh, but these things have come up in the overall debate as it relates to the exclusionary rule. So I wanted to make sure that I passed all of that information on to you. So with that being said, how do you invoke or challenge the reasonableness of a search, and that would be invoking the the exclusionary rule. So the first step in challenging the reasonableness of a search is filing a pretrial motion to suppress. Now, most states and federal courts place the burden of proof on the defendant when the search or seizure is based on a warrant. And why do you think that is? Let's take 2 seconds, okay, maybe 10. Why do you think the burden of proof, why should the defendant have that burden to prove that there was a violation when it's based on a warrant? And think back to when we talked about warrants. Well, the reason for that would be, and we might talk a little bit more later, is that if it's based on a warrant, remember, a third-party magistrate or a judge has had the opportunity to read the warrant and sign it and approve it. So it's a third party. So the burden of proof then falls on the defendant. Now, with that said, the burden of proof will shift to the government or the officer or the DA, etc., when the police act without a warrant. So you can see how that presumption basically kind of shift. And why would that be? Well, again, just kind of running through the whole thing. A warrant has been issued by a judge based on evidence presented by the government that meets that probable cause standard. And the presumption is that the evidence on which the warrant is based will satisfy that probable cause standard. And again, the presumption, or the defendant then is assigned the heavy burden of demonstrating that the warrant wasn't good or it was deficient, etc. Now, again, the government, it switches, bears the burden of proving that a search warrant was justified as an exception. It switches when there is no warrant. So those are, but this is kind of the start about how do you invoke. Now, if the trial judge decides to admit the evidence at trial and the defendant is convicted, the defense, of course, may appeal and raise the issue whether the judge made the correct decision in admitting the evidence. And we've talked about that a little before. So a decision by the judge at trial to admit the evidence results in the evidence, again, being introduced at trial. And again, following conviction, the individual does have the opportunity to challenge that on the fact that the judge maybe did not make the correct call on something like that. And sometimes a decision by a judge to admit evidence is challenged by a defendant. There's a case called Chapman versus California. And in this case, we kind of learned something called the harmless error rule. And this requires that the prosecution established beyond a reasonable doubt that there is no reasonable probability that the evidence influenced the outcome of the trial. So if the evidence is actually allowed to stay in. So hopefully that kind of makes sense. So that would be the harmless error rule. And that's the case, again, Chapman versus California. Okay, so with that being said, we're still talking about how to invoke the exclusionary rule. So a defendant is required to have something called standing in order to challenge the introduction of evidence at trial. In other words, a defendant may be surprised to learn that they may not be eligible to contest the legality of a search. And hopefully that kind of makes sense to you. So again, as part of invoking, you are required to have standing, and we'll define that a little bit further. But basically, you need to have this thing called standing in order to contest the legality of a search. And in 1969, in a case called Alderman versus United States, the Supreme Court held in this case that Alderman, the defendant in this case, did not have standing to suppress evidence obtained through an illegal wiretap of a co-defendant's telephone conversation. And the Supreme Court in this case explained that the extension of standing to individuals whose personal rights have not been violated would significantly increase the costs of the exclusionary rule. And the legal test to be applied for standing in the case of an alleged violation of the Fourth Amendment prohibition on unreasonable searches and seizure is whether the defendant has both a subjective and an objective reasonable expectation of privacy in the area that is subject to the search. And I'll give you some examples in a minute because I know this is like a lot of legal stuff. So the burden of proof, again, is typically placed on the defendant. And I'll give you a couple of examples. I'm not sure if I cited any here. I may not have. Actually, I did. Okay, so just to kind of back up, I wanted to give you one other. Here we go. When you talk about standing and the legality of a search, etc., this video is a little bit long, but it's an individual that typically goes around from town to town, from city to city, and he records officers doing traffic stops and other things. And this is a case where he records the officers making a stop on a vehicle where they find a handgun. And the stop is a little bit long, and there's a loaded firearm that's found. And I want you to kind of just watch the stop if you have time. You don't have to. And listen to what he says. And kind of decide if you can, were there any issues regarding the car stop. The next term that's important that we know before we move on would be something called habeas corpus. And this basically means in Latin, you may have the body. And basically what habeas corpus is, it's a request to the court to basically require the government to bring a person who is in custody before the court to determine the legality of a detention. So I wanted to make sure that that term got out there before we jumped into standing. So again, and I'm trying to make it simple to understand standing, a defendant is required to have standing to challenge the introduction of evidence at trial. In other words, the defendant may not be eligible to contest the legality of it. So I'll see if I can find a couple of good examples, and we'll talk about them. So the first one, let's say automobile passengers. So here a police officer stops a car that they believe was fleeing the scene of a robbery. And a search uncovered a box of rifle shells and a sawed-off shotgun under the front seat. And in this case, the two petitioners, the two people that are trying to fight this arrest, were passengers, neither of whom owned the automobile. Now, in this case, the Supreme Court ruled that the two petitioners lacked an expectation of privacy in the glove compartment and under the seat, and held that they lacked standing to suppress the evidence. So again, standing basically means that you are, maybe you're in charge of something, like your vehicle or it's your purse. An example could be if somebody gave you, or you gave something for someone to hold. So you go to a party, let's say you have something that you shouldn't have, you give it to someone else and they're actually holding it. And law enforcement were to come in the room for whatever reason, and they detain everyone and they find the illegal item in the belongings of the person that you gave them to. Well, you don't have, that's not your backpack if it was in, or a purse or whatever. So you don't have the right to object to that search because you don't have standing. And I'm trying to kind of help you clear that up. Let's look at another one, overnight guests. The police entered a home without a warrant or consent looking for an individual by the name of Olson, an overnight guest who was wanted for suspected involvement in a robbery murder. And Olson was found hiding in a closet. And here the Supreme Court held that the overnight guest, such as Olson, possessed a reasonable expectation of privacy in the home. The court held that to hold that an overnight guest has a legitimate expectation of privacy merely recognizes the everyday expectation of privacy that we all share. So there's more examples, but again, all of these can, and there's like 1, 2, 3. There's about 6 or 7 examples on page 361. But you need to have this thing called standing. So the standing doctrine, maybe I can kind of sum it up a little bit, is a method of limiting the cost of the exclusionary rule by restricting the number of individuals who are eligible to challenge the introduction of evidence. And the Supreme Court has also limited the cost by creating a number of exceptions to the exclusionary rule. So, like anything else, there are actually some exceptions to the exclusionary rule. So, is the deterrence gained by excluding the evidence outweighed by the cost to society by excluding the evidence from trial? And now let's take a quick look at some exceptions to the rule. Actually, this might be a really good place. We're at about the 50-minute mark. So let's take a break right here as we're finishing up with standing, and as we start to look at some exceptions to the exclusionary rule. So this will conclude part 1 of the chapter 10 lecture on the exclusionary rule and entrapment, which we'll hit at the end.